fundamental principles of democracy, integrity, fairness, transparency, and respect for the sovereign will of the people have formed the basis of Jamaica's efforts towards electoral reform. The matter was first placed on the agenda for electoral reform as far back as November 2003, it being recognized that the existing provisions in the law, which are found in sections 55 through 61 of the Representation of the People Act, are deficient and do not provide an effective mechanism to regulate the financing of elections.
That changed between December 2015 and January 2016 as both houses of Parliament approved amendments to the Representation of the People Act, reforming how political parties and candidates can access campaign financing. Among other things, the amended legislation establishes a national election campaign fund to receive and make contributions to candidates and registered political parties. Contributions to the fund will be held at the Bank of Jamaica and can be invested to increase the pool of money. Contributions must be declared to the Electoral Commission of Jamaica within 14 days after they are made. Individuals, companies, other entities, and Jamaican diaspora groups can all contribute, but there are donors from which registered political parties cannot knowingly accept contributions. Among them, foreign or Commonwealth governments or their agents and public bodies. Contributions are also not allowed from illegal entities, intermediaries, or persons and entities whose identities are not disclosed or found to be false. Breaching the rules could result in a fine not exceeding $3 million or imprisonment for up to 12 months. To protect themselves, a registered political party or candidate in receipt of a contribution from an impermissible donor can return it within 30 days of receipt. Meanwhile, contributors can face a $1 million fine if they fail to declare whether they have entered into any government contract valued at over $500,000 2 years before or after making the contribution.
If the contract is entered into within 2 years after the contribution was made, then the declaration is to be made to the Commission within 14 days after the contract is entered into.
Monies can only be disbursed from the National Election Campaign Fund when candidates have met all compliance requirements certified by the Political Ombudsman. Disbursement is done using a formula based on the amount of votes candidates received, and there is a limit to how much each person can get.
And that limit provides that the disbursement to the candidate from the fund, together with any other funding provided to the candidate, shall not exceed 40% of the lesser of the total expenditure that the candidate is permitted to have incurred in the campaign period under Section 52BI, or the actual expenditure incurred by the candidate.
For accounting and transparency, a registered political party or candidate must get an invoice showing the market value of goods and services received. Contributions are tax deductible. Management of the National Election Campaign Fund is the responsibility of the Director of Elections under the direction of the Electoral Commission.
The fund is to be audited by a firm of auditors designated by the Commission, and furthermore, the Auditor General shall at all times have the right to audit the fund.
The Electoral Commission has the power to serve disclosure notices and to request disclosures from contributors and registered recipients. Regulating political campaign financing, bolstering transparency and accountability of elected officials, increasing the ability of Jamaica's electoral system to deliver free and fair elections in accordance with the rules of law.